ladies and gentlemen. Nice to see you all back. So as I explained to you yesterday, we are now at the portion of the proceedings where counsel for each side gives you their closing arguments. And so we will start with Attorney Sisti when you're ready.
Thank you, Your Honor. Good morning, folks. I think I want to start by telling you a little bit about closing arguments. But before I do that, I want to thank you, and Jason wants to thank you. It's a tough case to sit through. Tough evidence. The videos are tough. They're critical, but they're tough. You saw a pretty gory video, a scene video where there was some medical work done on the alleged victim on the 4th of April, 2024. That's tough to take. I mean, we all know that. But we do hope that you hold to your oath and that you objectively look at this evidence. Okay? I mean, it's really important. I don't know how to stress it. I don't get to speak to you again after this. I mean, I'm handing Jason off to you this morning. That's what I'm doing. He's totally out of my control now. Okay? We trust you. Okay? We trusted you when you all said you can give him a fair trial. He trusts you. And, it's quite a process. I'm sure that you look back at this process years from now and say it's pretty impactful. I'll tell you something else. You can kind of exhale a little bit because there's a rule. I mean, we can't go on forever. There's a rule in this state where I can only use up as much as an hour. Prosecution can only use up as much as an hour. Then the court instructs you, and it's all yours. Just like the view that you took control of. That was your view. This is going to be your case. You're going to own this case. This one's yours. You take as much time as you need to deliberate when you get it, and you go over it carefully, okay? Review all the evidence, and come to a reasoned conclusion. All I'm going to try to do during my 1 hour is to try to guide you as to where we're going, okay? What we're doing. And from the very beginning of this case, when I first had the opportunity to discuss this case at all with you, it hinges on self-defense. And let's just cut right to it. You know it. Okay? You know it. And you feel it in your bones now. And you've seen it on video. Okay, but I want to start filling in the blanks a little bit for you and giving you an overview on what this thing's all about. Because you're going to get instructions. And they are quite helpful. And there'll be a handout. That I'm actually going to refer to a little bit during the closing. But you're going to have it, and you'll be able to go over it and use it as long as you want. And what the jury instructions are, quite frankly, they're like a guidepost. They're the law. It's like a roadmap. And you plug in the facts, and you use this law, and you're going to come to the right decision. Okay? Right? That's the whole idea here. Now let's talk about what went down here. Okay? And really, the case starts before April 4th. It actually starts a few months before April. And a few months before April 4th, none other than Kyle Violet, for some insane, crazed reason, approaches Jason while Jason's minding his own business. And this is going to be a repeating theme, by the way. While he's minding his own business, doing work on his house, an enraged, delusional Kyle Violet approaches him and does what? Threatens him for no reason at all. For some paranoid, made-up reason. And the paranoid, made-up reason back in October of 2023 was that Jason was informing on him to the police, which has no basis in reality.
Excuse me, can someone help us?
Oh,
jury be removed, please? Okay. Thank you for your patience, ladies and gentlemen. These things sometimes happen during trials. As my staff informed you, the gentleman who had the medical incident during the proceedings is doing well and has been seen by medical staff. And so at this point, we're going to reconvene. Obviously, what happened in the courtroom has, as you can imagine, has no bearing on your decision in this case one way or the other. So I ask that you not give any further thought or consideration in terms of your role as jurors in this case. And so we're going to continue with Attorney Sitsu's closing argument. Attorney Sitsu, whenever you're ready.
Thank you. And thanks for hanging in there. I was telling these guys, you got to see me do what I used to do a long time ago. He's okay. All right. Okay, let's start this again. I'm not going to go over this for 7 or 8. I want to get back to the very, very basic principles of why we're all here. And basically, why we're all here is to give Jason a fair trial and to follow the principles of law as they were outlined to you by the judge. And we'll go right back to the beginning. It was proof beyond a reasonable doubt, burden of proof, presumption of innocence, and then, folks, the additional thing in this case was self-defense. And you all got a grasp of what that was. And you got to see some of it during the course of the trial, and now I'm going to try to explain where we are with this thing. Like I said, this is an interesting case. It's a self-defense case. There's no question about it. And there's some very graphic material in here, very graphic medical material. You saw that video, and you heard about what was taking place. They're heroic medical procedures, I can assure you, that kept Kyle alive. And he was very lucky to have a combat-trained individual on scene at that point in time. That's all I can tell you. And he's alive. So the gory film that you saw, frankly, is not at issue. The injuries were very significant. Okay. There's no question. Gunshot wounds themselves are very significant. These were very significant. But this is a rare incident, folks, where you get to see somebody, in this case, Kyle Violet himself, the centerpiece of the prosecution's case, in a situation where not only was he threatening on April 5th, something that he had done before with Jason, and I'll go back to that, the October incident, for no reason at all, the threat to his life, the threat to his family's life, right in front of his own home, for no reason at all. And we almost have an instant replay of that. But this time it's even more bizarre, because this time the claim is that he's plowing snow into his driveway or something to that effect. The beautiful thing in this case is that you have some film that you can actually look at. And if you look at it, Jason is actually being extremely careful in the plowing, not to interfere 1 inch into Violet's driveway. And he's minding his own business. Jason had gotten up on April 3rd at about 8 o'clock. By the time you see him plowing, all right, he's already into about his 38th hour of being awake, of working, not just being awake, but working. Now let me suggest something. When you go back into the jury deliberation room, you may want to do this. You may want to take a poll of everybody back there and ask who back there has been up for 38 to 41 hours in a row ever in their life. Ever. Ever. And you may want to say, if somebody does raise their hand, how did you feel? Did you feel with it? Were you working during that particular period of time? Were you in a combat situation? Just what was it? Were you in the comfort of your dorm room or your home? You know, get the context. But I assure you, if there is somebody that was up that long, they will tell you that they were worth pretty much nothing mentally, pretty much nothing physically at that point in time. You can all relate to that. I mean, there's nights where you just want to go to bed, even though you've been up for only 15 hours. This is more than twice that length of time. So when Jason is confronted by Kyle Violet on the evening of April 4th, 2024, we know for sure from the video that Violet initiated the contact, and he literally, physically assaulted Jason. He placed his face intentionally on Jason's face. Now, why would somebody do that? And again, what would a reasonable person believe if somebody did that to them out of nowhere? Well, Violet did it to threaten him. The physical act alone was a threat. I mean, imagine that. Imagine somebody coming up to you out of nowhere and sticking their face right onto your face. But it's not just sticking its face on your face. It's threatening them at the same time. And it's threatening him at night while he's minding his own business at his home with his daughter in his truck. That's the context. That's the very context of when this starts. That's the alpha. That's the beginning. Kyle Violet really is the alpha and the omega of this case. He started this. You know, you wouldn't be sitting here at all. Think about this. You wouldn't be sitting here at all but for Kyle Violet. Why did everything go down like that? What was that scramble all about? It was all about Kyle Violet. He placed himself in a position intentionally to threaten Jason. To threaten Jason with death. There was nothing conditional about sticking his face on Jason's face. And there was nothing conditional about threatening him. And you'll see that it happens more than once. When you run that video, you take a look at how many contacts he had with him. I mean, what was he trying to prove? What in the name of God was going through his head? Other than to try to scare hell out of Jason Levesque. And to relive that same threat that he'd had with him months before. And again, it was for no reason whatsoever. None. Zero. So we know that he initiated the contact. We know that he stuck his face into Jason's face. We know that he made threats. And he made multiple threats and multiple approaches. Now, I'm going to ask you, I'm going to go through self-defense instruction in a second, but I'm going to ask you, do not abandon your common sense when you sit here. When you looked at that, what did you see? Did you see some cool, calm guy coming out to say, please move some snow, please don't block my driveway? Or did you see an enraged, out of control, insane guy coming up on somebody minding his own business in the middle of the night? And that's the context that you have to take this case. And you're going to hear from the judge that you have to basically run it through the lens of what was going on that night. Not today, when we're all sitting in a courtroom, cool and calm, rolling it over in our heads, and going frame by frame, like Detective Dan did. Because that's not reality. The reality is that this whole interaction took about 11 seconds. This is quick stuff. Quick decision material with a man that was shocked that he was even going to run into Kyle Violet that night. There was no reason for it. Reason means something in this case. If you think for a second that Kyle was not threatening, that Jason was not threatening, then you gotta think twice. Anybody would have been threatened in that situation. Anybody would have been concerned about protecting themselves. Anybody would have been concerned about protecting themselves when somebody's saying that they're going to kill them, or kill their family, or both. That's the context that we're dealing with. That's the case. That's the case in a nutshell. But frankly, it's more than that, because Kyle, he wouldn't give up. If you look at the video, he walks away, and you'll see his arms all over the place. You know what's going on there. And you see Jason standing still, doing nothing. You've got one madman screaming at Jason Levesque, doing nothing. And then he starts back at him. And that happens a couple times. And the last time he comes back at him, he's screaming at him and he's telling him, "You don't know me, you don't believe it." The threats keep coming. Threats keep coming. And I'm going to ask you something, okay? How many times do you have to put up with that? Do you have to wait until somebody comes at you with something? You know, Jason Levesque didn't have the wonderful experience of what the deputies do in this courthouse when you enter through the front door. And that is check people out, see if they have any concealed weapons or metal or anything. He had no idea what he had. None. And you'll hear in the instruction that he doesn't have to even be threatened with a weapon. All this questioning about, did you see a weapon? Does he have a weapon? When you got there, did he have a weapon? Guess what? That's a mirage. That's a mirage. All Jason has to believe at the time is that somebody is out to kill him or cause serious bodily injury at that time. Not 5 hours later, not 2 hours later, not 2 minutes later, certainly not a year later. But at that time. What would a reasonable person believe at that time? After somebody who had threatened you months before for no reason, and then came out of a house and threatened you again for no reason, and threatened death to you, was coming at you. What would a reasonable person think? Think something good was going to happen? Think they were going to talk it out? He was violent, he was threatening, and he was out of control. That's what Kyle. That's what you were dealing with. That's what Jason was dealing with. And you know, you can put as much lipstick on a pig and earrings and bracelets and everything else that you want. But at the end, it's still a pig. Kyle Violet is no innocent human being. He bears the brunt of starting this thing, creating the situation, and the reaction from Jason. He bears the brunt of that. Nothing would have happened but for his behavior. Nothing. Now, in this case, you got to see a breakdown, and you heard testimony from Detective Danny. And remember, he got to go frame by frame. Remember what he was doing? It was kind of cool, but I mean, it was frame by frame. And something that, of course, Jason wasn't able to do. I mean, retrospective observations are interesting, all right? But that's not the test. But I'll tell you something very important when you do frame by frame and you listen moment by moment of what you can hear. It may be very, very telling as to what was going to happen. In fact, Angela LeChant was almost a prophet of what was going to happen that night. And she took the stand and she raised her right hand. She swore to tell the truth. And she made something up. Right here in front of you. Not after a traumatic event. Not after over 40 hours of being up. Not after 24 hours of work. She made something up to skew the case, to hoodwink you guys. Angela LeChant, Kyle Violet's significant other, made something up. I'm sitting there wondering, is the prosecution going to hug what she said and urge you to believe her during their closing argument? I think not. Because what she said, in coordination with the video, is basically the prediction of the future that took place just seconds later. What she said is impactful. It's her present sense impression of what's going on with Kyle Violet. That's her watching her significant other going down the driveway and confronting Jason. And Detective Danny captured it. In fact, at 10:11:22 on the 4th of April, 2024, Angela LeChant is heard saying, quote, "Yep, there he goes. I don't know. He's all the way out there. He better not do anything stupid." Now let's just stop. What do you think she's talking about at that point? It can only be one person. It can only be one person. And that's Kyle Violet. She's watching her significant other, and you'll see it in video, coordinating with her speech, going across the driveway and approaching Jason. And just a few seconds later, Angela says, he better not do anything fucking dumb. Who do you think she's talking about? Jason's just standing by the truck when she says that. Who is in Jason's face? Kyle Violet. Now that's black and white. That's obvious. That's obvious. But she still had the gall to tell you, no, I was actually talking about Jason. And that's absurd. That's ridiculous. Frankly, if you want to know the definition of a lie, that's a lie. That's a lie. That's an intent to deceive. That's an attempt to put a thumb on the scale and try to convince you guys of something that just wasn't happening. That's just something that's out there in outer space. That's Angela. That's Angela LeChant. What really happened that night, she could almost tell was going to happen. Somebody was going to do something stupid. And you saw it. Now, self-defense case, there are many, many items you have to go over, and this instruction is going to help you out. Okay? And the judge is going to tell you that evidence has been presented that the defendant has acted in self-defense. When there's some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. I mean, that's a heavy, heavy burden, okay? They have to disprove self-defense beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. If you believe, in other words, that his reaction and his actions that night were centered around self-defense, then it's a not guilty. It's clear. In deciding, this is critical now, you're going to hear it again, and you're going to have this instruction. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident. All the circumstances surrounding the incident, which include the prior threat, all the work he did that day, his exhaustion, the fact that he was put upon by surprise, and that he was threatened. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. So you have to step back. You have to see how he would have been seeing things at that time. Okay? Not under a microscope, not after, clear, detached reflection. None of that. But at the time. These things happen quickly. And that's why this particular instruction is important. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. Not coolly and calmly. Right? Not rolling it over in his mind. But reacting to what was presented to him at the time. It gets better. A person has the right to use deadly force on another person to defend himself or a third person if three conditions are met. He actually believed that the other person was about to use deadly force against him or a third person. It doesn't say that he thought the other guy had a weapon. It doesn't say anything like that. All this weapon stuff is an illusion. He doesn't have to frisk him and see if he's got a weapon or not. In other words, the defendant can use deadly force if he actually believed that he or a third person was in imminent danger of death or serious bodily injury from another person. Serious bodily injury, ladies and gentlemen, can be as much as a sucker punch from a madman that breaks your nose or knocks you to the ground or whatever, okay? And folks, if you were looking at that film objectively, it almost looks like it could have just happened any minute. Any second. Forget about minutes. There's a definition of serious bodily injury. For purposes of understanding self-defense, it means any harm to the body which causes severe, permanent, protracted loss or impairment to health or function or any part of the body. Not a bump or a bruise or a scratch. We're not talking that. That wouldn't constitute serious bodily injury. And as the words imply, serious bodily injury requires a serious or significant injury. Could he anticipate a serious bodily injury? Yeah, when somebody's threatening death, you can kind of get to that spot. Even if the defendant actually believes that such danger existed, that is, that either he or some other person faced an imminent risk of either death or serious bodily injury, that belief must have been reasonable. I want to stop right there. You saw everything. You heard everything. You understand what's going on. I don't want to be preaching to the choir too long. How could he not have a reasonable belief that this maniac meant what he said? When he came back at him the last time, he said, "You don't believe me?" In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful deadly force against him or a third person. And here's the key. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the other person was about to use unlawful deadly force. Again, check that box off. He must reasonably believe that the amount of force he used was necessary for self-defense. You know, he said on and on and on and on and on, that he was trying to protect himself, that he was trying to protect his family. Look, I'm going to get into his testimony in a second. But to the police even that night, in the condition that he was in that night, that's what he was saying. A person's not permitted to use excessive force in self-defense, only a reasonable amount of force. And again, this has to be interpreted from at the time that he was perceiving these events. The defendant can use the amount of force which he believed was necessary under the circumstances, as long as, at the time, there was reasonable grounds for his belief. Folks, reasonable. One can very easily come to that conclusion, that his reaction was reasonable because he was put upon by an unreasonable human being. That he was put upon in a savage situation with threats of death in the situation that he was in. Let me tell you something, okay? Jason went through quite a bit that night. Not only was he exhausted, not only was he threatened by this maniac, but he was trying to care for his daughter as well. He was worried about his parents. Of course, he was worried about himself. And he was exhausted. So what happens after this thing happens? Is it somebody saying, "Oh my God, I'm going to run"? No. Actions speak a lot louder than words. Jason Levesque stayed right there. He didn't make one move to leave. There may have been an off-cuff comment to his daughter that, quite frankly, is stupid and doesn't really amount to anything. He never tried to evade the police at all. In fact, there's evidence that he even dialed up 911 and just didn't hit the button because he heard the sirens go. It came from him, it came from his daughter. And it also speaks to the fact that he stayed there. It also speaks to the fact that he made the firearm safe. He prepared for his arrest. He placed the firearm in the dash. He took the extra magazine out of his pocket. He secured that. And when the police came, he stepped out of the vehicle, he raised his hands, and he cooperated all night long with the police. That's not somebody that's fleeing. That's not somebody with a guilty conscience. That's somebody that's waiting and anticipating and then cooperating with the police. Just like an innocent person would do. No resistance, no lip, no nothing. When they asked him to get in the cruiser, he got in the cruiser. When they asked him if he could go to the police station with no problems, he went. And we got to the police station, folks. You saw the video. I want you I want you to watch that video. About 20, 25 minutes long. Okay? And in the video clip, you're going to see a human being, all right, that is wiped out. I can't even describe it. This guy can hardly take his own sweatshirt off. He's cold. He's hot. He's nauseous. He's laying down on the floor of the interrogation room. That's just the beginning. There's almost 3 more hours of that. Do you think he got better over time? Do you think that's a good environment to get factual, actual, accurate information from somebody? Be surprised if he could tie his own shoes at that point in time. But they took a statement from him, a lengthy statement, and he was sitting there as long as they wanted to take it. This isn't somebody giving him lip. This isn't somebody that's resisting. This isn't somebody that's uncooperative. This is somebody like just what he said on the stand. He was just trying to help put it all together. Do you think somebody actually has a vivid, accurate memory? I actually draw on this a little bit. After being involved in a shooting, for the first time in his life, by the way. I mean, this guy doesn't even, like I said, he never even shot a chipmunk in his life. Do you think that doesn't shake you up? You think that doesn't scramble you? You think if you add that to the threats, that doesn't scramble you? You think if you add that to the fact you've been up for 40 hours, that doesn't scramble you? You think if you add that to the fact that all you're getting is a glass of water and a Slim Jim, that doesn't scramble you? That's the context of the 3 hours, over 3 hours, of interrogation with Jason. But did he complain? Did he say, no, I don't want to do it? No. In fact, the entire night, this guy is cooperating with the police. Can we search your truck? Yes. Can we take your video info? Can we take your cameras? Can we take your hard drive? Yes. Can we have the password? Yes. Okay? Yes, yes, yes. Will you speak with us? Yes. Can we swab your hands? Yes. Everything's yes. He's trying, okay? Was he perfect in the interrogation? No. And you know what? Nobody would be. Not under those circumstances. Nobody would be. The honest answers are that he's doing everything he can, not only to help the police, but he's doing everything he can to try to explain what went on that night. He tried to do it with you guys. And you know it. He didn't have to take the stand. You know that, right? He didn't have to subject himself to cross-examination, and Attorney Barth's very good at it. Been doing it for years. He's very good at it. He didn't have to do that. He didn't have to put up with that. Nobody forced him to go up there. Jason Levesque went up there because he wanted to look at you folks in the eye and tell you the best he could as to what happened. Not skewing the facts, not lying, not deceiving you, not playing games, not changing stories. Is it unreasonable, for instance, for somebody in that situation to not remember each and every time he pulled the trigger? It's an automatic. It goes on automatic. He's pulling. It's not done till it's over as far as he's concerned. And what's his concern at the time? Protecting himself, protecting his daughter, protecting his home. This thing happened right on the front steps of his home. Right in front, pretty much, where his mom and dad were sleeping. Right there. No lies and deception. That's a red herring. I'm going to urge you, take your time when you're deliberating. I'm going to urge you to listen to everything that's going on in those tapes that you have, and watch everything that's going on in those tapes. Okay? You know, Detective Garston spoke of tactics and, you know, training and all this stuff for interrogation. You know, maybe he was running an interrogation with tactics and training and everything else. Jason Levesque, he's not sitting there constructing a self-defense defense. He's not constructing anything. He's trying the best he can to cooperate with the police after a traumatic incident. A first for him. Shooting anything that was living and breathing. And you'll hear Garston. You'll hear him in that tape. Listen closely. When his body cam is not switched off, and he's talking to another officer. And he says, let's talk to this guy now. Let's talk to him now while he wants to talk. Okay. They got him in their place. They got him while he's exhausted. They got him while he's easy pickings. And you know what? They know deep in their heart they got a very frail human being that probably isn't going to be the best person in the world to get accurate information from. They could have circled around 5 more times and probably gotten 5 more answers. Because even yesterday, Jason's not sure exactly of what happened that night. You know why? Because the body tries to stop remembering things like that. It protects itself. It goes into shock. It tries to get rid of memories like that. And those are difficult to bring back accurately all the time. There's nothing unusual about that. Any trauma situation, there's nothing unusual. It's typical, it's human, it's natural. Some of you may have experienced this. Prosecution, in this case, for lack of a better analogy, was dealt a lousy hand. In order to get a conviction in the United States of America, in a courtroom like this on a criminal case, you got to hold aces. You got to prove the case beyond a reasonable doubt. Okay? No goofing around. No halfways. No maybes. No probablys. No could-haves. None of that stuff works. The only way they get a conviction in this case is to prove beyond a reasonable doubt each and every element of the offense charge, each and every one, beyond a reasonable doubt. And they have to disprove self-defense beyond a reasonable doubt. And in this case, ladies and gentlemen, they got dealt a lousy hand. They don't have 4 aces. If you flip their hand over, what they really have is a bunch of jokers. And the joker in the case is Kyle Violette. They got dealt Kyle Violette. And when you get dealt something like that, that's a gigantic reasonable doubt. And when you get dealt somebody that acted the way he acted in a self-defense case, that's a lousy hand. But don't feel sorry for him. This isn't about sympathy. It's not about worrying about their case. It's about critically analyzing their case and making them prove their case beyond a reasonable doubt. You have to make them prove
And if they don't, you understand that in the United States, you're doing your duty. You're doing your duty by coming through the doors of the deliberation room at the end of a trial and at the end of running through all the evidence, coming through and saying not guilty. That's the justice in the criminal justice system. It's not doing favors for the state. You don't do that. It's holding them to their burden. And I pray you do. I mean, there's a lot of junk that's going on outside of this courthouse. You all know. I mean, our country's divided all over the place. All kinds of junk going on. Okay. Maybe the purest form of being a citizen right now, the purest form of being a citizen in this country, the purest form of democracy in this country, the purest form of doing your duty as a United States citizen in this country right now is in courtrooms just like this, with jurors just like you. Think about that. You're really the reflection of this community. You know that. Right? When you go back there, you're going to see you come from all different walks of life. You all have your own talents. You all have your own backgrounds. And you all have common sense. And if you all work together in this, if you all put your minds together, all 12 of you when you get back there, you're going to come up with a very just decision by using your common sense, looking at that evidence, being critical of the state's case, and following the rules. So, ladies and gentlemen, I'm going to ask you. I can't do anything anymore for Jason. I can't do things. And all I'm doing is putting all of my trust in you guys. And so is he. Okay. So really, take great care in your deliberations. Be sure to follow the rules. Take all the time you need. And thank you again. I appreciate it. Really. Thank you.
Thank you for insisting. Thank you, everybody.
You know, I want to talk about two words that were touched on in that presentation. But I want to talk about those two words in the context of the shooting. Before and when Jason Levesque decided to shoot. And this isn't a case just of a shot. This is 6 shootings. And I want to talk about these two words in that context. These two words are reasonable and imminent, as about to. And to be clear, these are not just words. These are the concepts and principles of a sensible law that buttresses against inappropriate and unnecessary deadly violence. Violence driven by notions of retribution, revenge, impulse, anger, and poor judgment. We guard against that with these concepts. These principles exclude unnecessary and pointless violence, but they also at the same time ensure for you, for me, for everybody, including Jason, the right to protect yourself, but within the boundaries and scope of reasonableness, reasonable force, reasonable belief of impending deadly force, reasonable degree of force to respond to imminent use of force, deadly force against you. That's the framework that needs to guide your analysis of the evidence. And that's what I want to talk about. Let's move on to evaluate really each chapter, each motion through this process. Not to dissect, not to impose some unreasonable analytical approach to Mr. Levesque's choices. But to assess his choices and his actions appropriately. Evaluate each one of these steps, these sequences, and you'll see that at each stage, after the initial confrontation, there is actually a cascading sequence of diminishing risk. From the moment Kyle Violet stepped away, there was diminishing risk. And I want to ask you to evaluate the steps in this case concerning issues like distance. Distance creates safety. Evaluate it. Distance can be closed and increased risk. Distance creates opportunity to assess risk. So at each one of those chapters of this case, consider that as a factor. The time. Attorney Sisti said this whole thing happened in 11 seconds. You'll have the totality of the videos. It took more time for Kyle to walk across from his driveway over to Justin. I mean, to Jason. There was 5 seconds nearly 5 seconds between that first shot, 2001, 2002, 2003, 1004, some 5 steps towards him before he unloaded the remaining 5 rounds into his back. Consider that distance and time when you assess reasonableness. Visual opportunity. The opportunity for Mr. Levesque to assess risk. The lines of sight here, the lighting. Remember at the beginning, there was one moment in Attorney Sisti's cross of Detective Danny were saying, look, you don't even know whether or not Jason is able to see his hands because of the lighting. And yet, we see a video from 43 where inside, from 40 feet away at least, Angela's able to say, he's got a gun. The lighting in this case was very good, illuminated by a high-density residential neighborhood with exterior lighting. You can see it in the video, a truck with its headlights on, and Angela having no problem identifying immediately when the gun was taken out, when Jason produced the gun, which informs you about Jason's ability to assess whether or not Kyle was armed. And so those are some of the issues to talk about, to consider when we actually walk through this. And let's do that now. This confrontation starts when Kyle walks out of his home. And despite Attorney Sisti saying at some point challenging Danny that Jason doesn't even seem to know he's there until he's at the Plow, we know this, that when Kyle was walking out of his home, Jason did see him. He had a full opportunity to view him from the full 40 feet here. You were out there at that scene. You know that distance from the far end of Kyle's driveway all the way over to that Plow. And we know he saw him because he told the police, I saw him putting on his shirt. You don't have to believe him. It's corroborated by the video. So we know he saw them at that point. And what does he see? He's putting on his shirt and he's able to describe his hands. You know, this is informative moment about whether or not there are reasonable concerns about Kyle's ability to cause violence of such a degree that would justify what happens next. And nothing in his hands. You can see him putting on his shirt. There's nothing underneath. No reasonable basis to believe that he's armed coming over. Jason admits that he can see his hands, that there are no weapons, that there's no means of imminent threat as he's walking over. And let me just address this one point that Attorney Sistis said, that no weapons is just an illusion. It's a red herring. That's nonsense in a case like this. It's true that there's this phrase in the instructions that say, look, he doesn't actually have to be in danger. But that means if somebody presented a firearm that was carved out of balsa wood and painted black, the actual threat of that is zero, but the perception of it could be reasonable. That's not this case. There still needs to be a reasonable apprehension that Kyle had the means, the ability to cause lethal, deadly force. And obviously something like weapons is highly relevant to that reasonable analysis, is it not? The face-to-face encounter. It's clear that there is contact. Jason's description of it actually says the tip of his nose touched my cheek. Let me be clear about that. There's nothing that's sort of appropriate. I'm not suggesting that's a good deed. Let me just clarify this point. It's non-deadly force. There's no suggestion that he is going to kill him with his nose. I don't mean to sound glib about that. I mean literally to say that dismissing that he didn't have a weapon and say that the encounter there is what drives this analysis is misplaced. Here's the reality. That moment passed without the use of deadly force. That's not when the shooting happened. And yet, in this courtroom, that is what was recreated by the defense. We literally had a recreation of the face-to-face, the nose-to-nose encounter. And you know what we never got to in that presentation, that recreation? Was when he took out a firearm, closed the distance, saw Kyle stop, turn, and shoot him in the head. Lower the gun and then advance on him and shoot him 5 times in the back. We didn't see that recreation, but that's what this case is about. It's on tape. That's an ace. Each one of those videos is an ace. You know what could have happened at that nose-to-nose assault? That's the definition of non-deadly force. And you know what Mr. Levesque would have been fully within his rights to do? Shove him. That is to use non-deadly force in response. That is another corollary of self-defense. You can defend against non-deadly force with non-deadly force. He may have even deserved a punch in the nose. Reasonable force. But to bring that whole episode forward as justification to shoot him is not reasonable. It is the most intense moment of this entire episode, and yet that's not when he was shot. And that moment was defined by non-deadly force. His hands were out. He had no weapon. He didn't claim to have a weapon. He didn't hint he had a weapon. Even in that moment, there was no reasonable basis. If he had shot him, would have no reasonable basis to do so, and he didn't. The moment passed. He made a threat. We accept Jason Levesque's characterization of that threat, repeatedly made to Detective Garston. Never wavered about that. Not too tired to use the term, that was verbatim. not too confused to say those were the exact words, not too confused to repeat the conditional threat over and over and over again when Detective Gersten revisited those issues to do his looping. Tell me what he said. Every single time it was a conditional threat. I want to talk about that. Let's be clear. If words are the basis to justify killing somebody, then words are really important. A conditional threat, these aren't just legal concepts, you know, I gotcha moments from the law. These are common sense analyses of words. A conditional threat is important, is different, because it literally buffers and defers both the act and a time period of when a threat may come to fruition. I know that sounds all legalese. Put it this way, something needs to happen, and it's going to happen in the future. And that diminishes the nature of the threat. It's not, I'm going to kill you for what you just did. That's imminent. Brandish a knife. I'm going to kill you for putting the snow next to the pole. It didn't happen. Something else had to happen. And it would happen in the future. And then, still, Kyle would have to have the means to actually do something lethal and violent. You know, I mean, there's some pretty common sense examples of this notion of conditional threat, you know. From this, you know, the real world. If you flirt with my girlfriend in the gym one more time, I'm going to kill you. The guy says, fine, I'm not flirting with your girlfriend, I'm not going to do it anyhow. If you cut me off in traffic one more time, I'm going to kill you. It's a conditional threat. I'm not going to kill you for cutting me off. It's different by nature, by assessing reasonable risk. Let me just talk about this condition too. You want to know what the biggest red herring in this case is? It's where Jason Levesque put the snow. That's actually the point. Attorney Sisti got up multiple times to point out with different witnesses, hey, that's not on his property, is it? No, it's pretty close. You heard from a bunch of different witnesses. No, not on the property, on his property. That's the point. The condition of the threat hadn't happened. And Kyle is literally saying that. He's not saying you put snow on my property, therefore I'm going to kill you. He said, if you drag that stuff out of your driveway and push it down in front of my driveway, then we got this problem. Didn't happen. According to Jason, it wasn't going to happen. And that literally redefines the notion of this threat. That's the point. It didn't happen. You can actually see Kyle continue to explain the conditional nature of it when he walks away from this nose-to-nose encounter. He's pointing at that snow and his own driveway. That needed to happen. And it diminishes any notion that Kyle Violet is about to act on anything. The law actually recognizes this distinction. This notion of complying or not complying with a threat. Here it is. This is in the justification of self-defense statute. A person is not justified in using deadly force on another to defend himself or a third person from deadly force by the other if he or she knows that he can comply with a demand that he or she abstain from performing an act which he or she is not obligated to perform. That's a very legalese definition of conditional threat. In other words, if you don't have to perform this pushing snow in front of the driveway, of Kyle's driveway, you can't use reasonable force. You can just not do it. You know, here's the difference. If somebody comes up with you with a knife and says, look, give me your wallet. You don't have to comply with that. You can take your gun out in the face of a knife, in the face of the threat of something that you don't have to do. You shoot them if you want them. Somebody comes up to you with a knife and says, hey, look, if you ever come into my home again and steal my wife's jewelry, I'm going to kill you. That's, you don't not only have an obligation to go into their house, you have an obligation not to. So it's sort of a very clear example of a conditional threat where you don't have to comply with it. There's nothing about pushing snow in front of in front of Kyle's property that he had to do and was therefore imminently threatened by it. And I get, we're spending a lot of time on this. My point is, in this particular case, words matter. Let me also just talk about the law, doesn't take away all options. I think we talked in Vladimir about sticks and stones can break your bones, but words will never hurt you, and that's a kindergarten notion of it. And we accept that in the real world out there, words can be scary, and threats that you probably don't hear in kindergarten, like, I'm going to kill you and your family, didn't come around. So there is another layer. And it's this. You're allowed in New Hampshire, under the same justification self-defense law, a person who responds to a threat, and this is as opposed to imminent deadly force, to a threat which would be considered by a reasonable person as likely to cause serious bodily injury. In other words, the basis of the threat is something like, I'm going to kill you. You can respond to that by displaying a firearm or other means of self-defense with the intent to warn away a person making that threat, and you don't commit a crime. The law has anticipated this very moment where it's just a threat, but not imminent use of actual deadly force. But the threat of deadly force, if you're armed, you can produce your firearm and say, no, you're not. It says nothing about then being able to shoot them for retribution, for your anger, for your offense, for your sense of honor. You can warn them away if it's a threat. And to be clear, Jason Levesque never claimed a standalone threat. He got up on the witness stand and made that claim because he's got to. He's got to get away from this notion of conditional threat, got to get away from the notion that he was just entitled to brandish a firearm. He got up there and said, after the nose-to-nose encounter, he walked away and said, you don't believe me? I'm going to kill you. Here's the problem with that. This is a credibility issue. When he talked to the detective, he didn't say once, he said twice, in clear terms. Again, this looping effort to clarify, is he committed to this specific issue or not? Said he stepped away, he was walking back towards his house, it was after the gesturing, and Kyle turned at some point. You got to ask yourself, was that in response to the defendant saying something? Because his response, according to the defendant that night, was simply, what, you don't believe me? And that had him walking back, sounding very much like an exchange. The bottom line is, no, there was never an additional standalone threat despite his claim. You saw this process work out, how it works. I showed him the transcript, 2 places where it was very clear that there was no standalone threat, and he said, oh, it's in there. If it was in there, you saw the process work out. His attorney could just as well get up there and show the transcript where I was being tricky and omitted it and say, oh no, here it is, but that never happened. The reason that never happened is because it's not in there. Jason Levesque never claimed there was a standalone threat. As I say, there's nothing appropriate about that threat, but Jason had legal recourse to brandish his firearm. Does this case change over his claim that his daughter was threatened? It doesn't. The same reasonableness, the same imminency of deadly force would have to necessarily apply to the daughter. And here we know, I'm not saying it's appropriate, but here we know that he never used even the term daughter. We don't even know that Kyle was aware that she was in the truck because he never gestured towards her, never pointed towards her, never invoked her name, or even specifically daughter. It was a broad brushstroke, horrible, inappropriate threat, but not one that imminently targeted his daughter, not this case. You know, we talked in kind of candid terms during voir dire about, you know, whether threats change for you if they concern your family. And of course, everybody's initial visceral response is, yeah, you threaten my daughter, I'm going to kill you. And that may well be, you know, a natural initial reaction. But this is for real here. You know, this is now the application of the law and the consideration of real-world consequences. This is not a conversation with, oh, your friends and family around the dinner table. This is what I'd do if somebody said that. This is the realization of what actually happens, you know, when you shoot somebody in response to being offended, to thinking there's some street notion of retribution that is appropriate. This is real world. And now we're going to apply real world standards. What happens next was the walkaway and return. The walkaway is important concerning, again, two issues: time, space, opportunity, diffusion of risk. Kyle walks away at least 15 feet away. The nature of the threat necessarily diminishes. If he has a screwdriver, that is, you know, sort of fancifully filling Jason's mind. He hasn't not only referenced it, it's purely fanciful. It's not a reasonable belief, but from 15 feet away, the screwdriver isn't going to do much good. You know, this whole issue of, well, he didn't go through a mag detector, so Jason didn't know whether he had a weapon on. There's no reasonable basis. He didn't reference a weapon. He didn't display a weapon. He saw his hands clear. But here's something to consider. What Jason Levesque knew was that Jason Levesque was armed. In other words, from that distance, he could have easily, if he was really concerned about imminent use of force from some weapon, he could have drawn his weapon. And at that point, still, he does not. Kyle is gesturing to the snow, gesturing back, really corroborating, if nothing else, just his conditional threat that snow needs to be moved before we have a problem. He turns back to his own house, and as I said, there is no new threat. His hands are in the open. But he does clearly walk back towards Jason. Response to, again, a comment or an exchange. We don't know because we can't pick it up on the audio. And then again, he brandishes the firearm. And the state concedes he's within his rights based on that threat statute. I said you can brandish it to a threat. But you can't use it unless there's imminent deadly force. And here's where things go south for the self-defense claim. This is the ace, the second ace. It worked. Brandishing the firearm worked. You can see Kyle Violette stopped. And it's not milliseconds before he was shot. There is time. Revisit this on the video, and I don't mean in a hyper-technical sense. View it from the claim that Jason Levesque is making. Oh, this was a millisecond. It's not. He pulls out his firearm back by the plow, and he starts closing the distance, clearly indicating he knows he's in control now. You don't close the distance if you're afraid somebody's going to break out a weapon, a throwing screwdriver, or anything else. He closes the distance, raises the firearm, and with unambiguous certainty, Kyle Violet stops, and he doesn't merely stop, he turns away. And you can see this from multiple angles. You can see this from that garage view. You can see it from the side of the house view. You can utilize that evergreen where you see him just come into view. Gun comes out, and he goes out of view. You can see it from the porch perspective, which is down at the feet, imperfect. But critically, what is visual is that his feet become reoriented, stepping away. Both feet are now oriented to across the street. He's clearly turned. This is before he's shot. That's time. Opportunity to see the threat diminish, to see that the brandishing of this weapon accomplished its end as justified in the law. And yet, he closes on him and discharges a firearm into his head, into his face, crashing through, smashing his jaw, and dissecting his carotid artery. He's in control. That was entirely unnecessary, unreasonable, unjustified. An unarmed man stopped and turned away from his gun and tried to kill him. The next 5 rounds, he shoots him in the back. The time frame is something like, and you can listen to the video from across the street that's just audio. It captures the first gunshot clearly. And do the count. Something like 4 to 5 seconds. Think about that. 1001, 1002, 1003, 1004. Bam, 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 bam. It's unconscionable. He's on the ground, crawling for his life. That's attempted murder. By the grace of God and the intervention of immediate medical assistance, he lived. But that's attempted murder. You know, this is incredible claim that we heard yesterday. You know, I asked him, do you think he's still a threat to you? Yeah, he was crawling towards my parents' door. Literally said that. That's incredible. It's like the cyborg scene out of the Terminator where the thing is crushed and still crawling on the ground and it's, you know, pursuit of murder. Except this isn't science fiction. The fiction here is from Jason Levesque that Kyle crawling on the ground with a nearly lethal, certainly would have been lethal without intervention, gunshot wound to the head presented some sort of threat to him, his family, or anybody else. The other thing he's crawling towards is his home. And that's obvious. And once again, we know there are other factors to show that Jason had no sense of impending threat or injury to him. He lowers the gun. You can see that in the video. He lowers the gun before he advances some 3, 4, 5 steps closer to the supposed threat before he unloads the additional 5 rounds into his back in lethal fashion. Look, you got to analyze that in terms of reasonable force, reasonable belief, and the imminency of threat. These are the moments. It's not the nose assault. Let's talk about intent to kill. We need to prove that. You can form a purpose within the meaning of the law in a moment's time. You need to have the conscious object of a certain result. There are plenty of practical examples of this, of bad decision making or regret doesn't take away the purposefulness of a decision. Geez, I shouldn't have had that extra martini. That didn't mean I didn't take out a shaker, a glass, pour gin into my martini glass. I may regret that, but I certainly still acted purposely. It can happen in a moment's time. A decision to pick up this glass or that glass is still a conscious object and a decision. Here the steps, though, are much more conscious and involved. Each act purposely. To take out the gun from a holster, to raise it and aim it, to advance towards a target to ensure greater accuracy and lethality, to pull the trigger, to watch him fall, to watch him crawl, to advance on him, to aim again, to pull the trigger each time. This is not an automatic weapon that just sprays out 6 bullets. Each time he pulls the trigger is a purposeful, conscious act seeking to create a result. That's an ace. Look at the nature of these wounds. A headshot, 5 additional shots that each found potentially lethal marks. He's got shots in both buttocks, clearly indicating he's not a threat, but all those shots were potentially lethal. You heard the doctor say that each one was in an area of critical vascular, nerve, and organ systems. One of the bullets through his buttocks blew out his abdomen, dissecting his bowel, requiring emergency surgery. Need I go into the details of these images, which the defense on the one hand dismisses as unnecessary, but at the same time, Jason Levesque gets up there and he is asked that critical question: why did you shoot him? Did you intend to kill him? No, I just wanted to stop him. Look at those images. Play that body cam of Sergeant Hurley saving his life. And you got to ask yourself, is that the intent of somebody just trying to stop somebody or kill them? That's an ace. Let me talk about Jason Levesque's claims that he made to Detective Garson. Confusion, memory, tiredness. Look, these lies that he made that we talked about were central issues required for self-defense. He didn't just happen to, stumble upon some misstatements. These are not the misstatements of, confusion, misstatements of fatigue, like his distance was off, fibs to cover for his pride or embarrassment. They are essential features to support a non-existing self-defense claim. If you had a bad memory, you were so confused or overwhelmed, you'd say to the officer, you know what, I don't remember that. I don't remember that moment. I'm confused about that moment, but he never said that. Instead, in response to Garson's questions about, well, what happened after you took out the firearm? He gives a vivid, pictorial account, a visceral account. He said, I took out the firearm. Did he stop? No. He continued to advance towards me. In fact, he hastened, his words, hastened his pace towards me. It had been 10 feet away, but then he rushed. And I could see in his eyes his aggression. All of it, complete fabrication and nonsense, but all of it essential for a self-defense claim. So what did you do? I fired. Stay on his feet? Yeah. That's not confusion. Confusion, I don't know what happened. He gives a very precise answer. Why? To justify the next 5 shots. Did he go down? No. He didn't appear to flinch. Maybe he flinched because of the noise. But I don't know if I even hit him, because he kept coming at me. Well, then what happened? That's why I had to unload those next 5 rounds. That's not confusion. That's not. I'm not sure what he was doing. He's coming at me, and he gives this vivid, nonsensical. The degree of mendacity is breathtaking. He literally says, I shoot him 5 times, and he holds his abdomen and turns away and walks back to his home. That's a self-serving lie to fabricate self-defense because he knows what he did was wrong and unjustified. Otherwise, we'd see kind of this random confusion of facts that some support, some don't make sense, some aren't corroborated. But it just happens to be that each lie is such a divorced distance from truth and happens to land squarely within a set of facts that would support self-defense if true. But we got some aces. We got videos that demonstrably show he's lying. Let me talk about some other aspects of the defense claims. That he was tired at the street side and therefore was having difficulty. We've got to adopt this 40 hours of sleep. First of all, that whole notion that he was up for 40 hours is a credibility question for Jason Levesque. He's working for a commercial plow company that has some liability, and you think they don't give them breaks over the course of the day, that they're not conscious about the amount of time somebody's on the road. He's operating a commercial plow where apparently even at that hour he is able to make precise judgments and assessments of distance, of force, to plow, to pick up his daughter, drive safely there, but he's too tired in the next 5 minutes to make rational assessments about risk and whether or not the Kyle is on his feet or not after getting shot in the head. Let me just say, he's not tired in the sense that that he's absolved of responsibility. He may be sleep deprived and dangerous, but that's a different matter. How about that he consented to the videos? Look, he's sitting there in this is another immunity card from the defense. Well, he gave him the video. Look, Garston heard about the video earlier on. He looped back at page 66. He hears about it at page 27, but he's the one who says, hey, you got video from tonight? And it's true, the defendant signed over the video. Do we know whether he's thinking, hey, maybe there's a Hail Mary here, that there is a kind of a perfect convergence of omission? It was pretty close. I mean, one of the videos just has him coming into view. The porch video is facing down. The garage video has only the sliver. And do we know whether he's making that calculation or not? I don't know. But we know he couldn't count on 43 pulling it all together, getting that arc of a view, that if you see these things in conjunction, you know that Kyle Violet stopped when the gun came out. You know, with the totality of these videos, that he was closing the distance. You know that there was sufficient time between brandishing the firearm, Kyle stopping, and pulling the trigger to assess risk. You know he went down after the first shot, and you know he came over to try and execute him with the next 5. That he gave them that video doesn't change any of that. Those are 4 aces. I hope he doesn't do anything stupid. Look, you want to talk about red herrings. Let's assume that she was talking about Kyle. Stupid doesn't mean that he's going out there. What she doesn't say is, boy, he's armed and dangerous. I hope he doesn't go out there and kill him. Stupid is going up and putting your nose in somebody's face and making a horrible threat that could have resulted in him brandishing a firearm or getting punched in the nose. But nothing about, geez, I think he's going to go out there and kill him. Red herring. Let's talk about this repeated mantra claim from the defense that Kyle Violet is a lunatic, a maniac. Look, maniacs run out into the road with a bloody axe and threaten you. Here, let's not forget the actual facts here. And they want to omit, the prior event with the snow to make him look like a maniac. You heard from Kyle's daughter. That's got to be one of the most objectively grounded, reasonable, pleasant witnesses we've seen. And she described being at home with her dad, who she adores, and planning a family night, sitting down at dinner, planning to watch a movie, but everyone went to their room, and they were getting apprehensive about the plow not showing up, and that they were all going to have to get out there and shovel, and the anxieties went up. And even Kira, Jason's daughter, acknowledged that, the first storm, we did plow in front of his place. And they did say something. We said, it'll melt. And so there was anxiety about that. I'm not suggesting, again, that the threat is reasonable. I'm suggesting it's not maniacal, that there is context for this, that there's history for it. Don't put that in front of my driveway again. It sort of diminishes the maniac view of this, doesn't it? And likewise, let's go through just some of these other efforts to assail Kyle's sort of humanity. The so-called prior event, what was that about? Talk about innuendo. I mean, we had, once we got into the detail of it, it's like, well, who is this guy? I don't even know if he was my neighbor. I couldn't pick him out of a lineup. Did you call the police on Kyle? No. Did you see Kyle again before this? He might have been taken out of his trash. You can't even identify that dude. And they're bringing that forward as some sort of an assault on his character to create an image in your mind that is much different than the guy who was having a family dinner and got anxious about having a hand remove snow. That's not fair. What about the claim that when Jason returned to his vehicle that he told a joke about running? That is more breathtaking mendacity. Somebody who just shot somebody this side of death can't possibly tell that kind of a joke unless they're a sociopath. And you know what? He has to recast it again, very much aware of his self-defense claim. If he got up there and admitted, yeah, I was thinking of running, it's an admission that he knew what he did violated the law. Because only people who violate the law and want to avoid legal recourse and consequences run. The first thing he says to his daughter is, should I run? And this isn't just a passing, moment. You heard what Kira had told the police. He asked me, should I run? I said, no, can't run. And he doesn't stop it there as a ha-ha joke. He says, well, then what should I do? Her response is not, oh, ha-ha-ha, you're joking. It's, this is your path. You've got to figure this out. Should I call 911? I don't know. And no, he doesn't. That's not a joke. That's an admission of a guilty state of mind immediately after these events went down. I'm in trouble. Not because he came at me after I brandished the gun. Not because he continued to come after me after I shot him in the head. Not because he continued to be a threat lying on the ground, bleeding to death from a dissected carotid artery. Because he was in trouble. He wasn't justified in shooting him, and he knew it. And that brings us to the police station where he contrives these litany of self-serving lies. We had heard in opening that you know, if Kyle wanted to kill him, he could have. He could have gone back and got another magazine. These images depict Kyle's intent. Excuse me, Jason Levesque's intent. Kyle Violet was as close to dead as you can get without a funeral. This is the intent to kill. There was no discretion on the part of the defendant to temper his use of violence. You got to weigh the reasonableness, the degree of that violence in light of the actual evidence. Take a look at it. I want to talk briefly then about this notion of Kyle's actions that create then a reasonable belief. He's on the ground in one instance and stopped in the next. And now you've been invited to view Jason's perception of that and to simply accept that whole cloth. That's not the standard. Jason needed to have believed he was in imminent threat of receiving deadly force. We know he wasn't because he was in control of the firearm. We know he wasn't because Kyle stopped. We know he wasn't because Kyle was crawling for his life when he received the next 5 rounds. But even, so that's the first prong. Even if you get there, you do get to evaluate this objectively to determine whether it's reasonable. And to dismiss it simply because he was tired is not the law. If he was tired, he should have used extra caution and care with a firearm and the actual use of deadly force. Being fatigued is not an immunity card. It doesn't dispense with objective notions of reasonableness. We literally heard from Jason Levesque up on the stand that, you know what, I don't even know what self-defense is. You lawyers getting tricky on me with this defense notion, self-defense. I didn't know what it was, therefore I couldn't have been contriving it. Here's a guy who explained that he carries a weapon because of a prior incident with some machete. Of course he knows what self-defense is. He literally explained that's why he carried. And yet we're supposed to believe he's too confused, too ill-informed, too tired to reasonably weigh out self-defense. He knew self-defense, and that's why he lied. He knew self-defense, that's why he carried, and he was supposed to carry responsibly. Look, ladies and gentlemen, I want to sort of address and end on this issue, another concept that we heard in opening statements. At one point, Attorney Sisti said, basically, this is the theory of the case. Kyle Violet got what he deserved. You know, first of all, to assess that, you got to take a look again at what Kyle got. And it's in these pictures. This is what Kyle got. And it was all from words. Grossly inappropriate words, but words nonetheless, not married to, not advanced by actual threats. And it is, you know, at this point that we invoke justice. That, I told you at the outset, it sounds kind of corny, and if I said this around my Thanksgiving table, I'd be asked to leave. But embedded in our civic duty, our civic culture, justice is sacred. The process of achieving justice is embedded, provided for in our Constitution, a process of determining justice. And it doesn't require that you abandon, as you've been invited to, scrutiny of Jason's actions, that the frame-by-frame viewing of whether he stopped or not is unfair. Because that's exactly what we do. We don't, get shamed away from judging these kinds of actions. What we do to achieve justice is, in fact, invoke this process. The prosecution has a burden to come in and present evidence to a group of citizens, jurors, who take an oath. This process makes our system of achieving justice probably the best in the world. Not perfect, but probably the best in the world. You evaluate that evidence in light of our burden, but using your individual and collective common sense and apply the law. You do that in this case. The path to justice is, in fact, guilty verdicts on both indictments. I ask you to endeavor on that path. Thank you.
Thank you, Counsel. All right, so ladies and gentlemen, as you can see, we've now reached the 12 o'clock hour. It's been a long stretch of sitting, so I'm going to take this opportunity for the lunch break. Thank you. Good afternoon, ladies and gentlemen. I hope you enjoyed your lunch. We are now ready to commence again. So, members of the jury, the evidence and the arguments in this case have been completed, and I will now instruct you as to the law that applies in this case. And after that, you will retire to decide your verdict. To reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you'll have to understand the definition of the crimes with which the defendant is charged, what to consider in deciding whether to believe a particular witness, and how convinced one way or the other you should be before you reach a verdict. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you. You must follow the law as I explain it to you, regardless of any opinion that you might have as to what the law ought to be. It is up to you to determine the facts in this case. You must decide this case solely on the evidence presented at trial and the law as I will explain it to you. You should reach a fair and just verdict without prejudice, without fear, and without sympathy. Now, the fact that the defendant has been arrested and charged is not evidence of guilt. The indictments are merely a way of giving the defendant notice of the charges against him. The indictments are a formal way of accusing the defendant of the crimes charged to bring him to trial. In your deliberations, you must not consider the defendant's arrest, the charges, or the fact that the defendant has been brought to trial as evidence of his guilt. The possible punishment the defendant might receive if you were to return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should base your verdict only on the evidence and the law without considering any possible punishment. You have heard the lawyers discuss the facts in this case, and you've heard them discuss the law in their arguments to you. These arguments from counsel are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers stated the law differently from the law as I explain it to you, then you must follow my instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. During your deliberations, you should consider only the evidence presented at trial. The evidence consists of the testimony under oath of the witnesses, the exhibits that were admitted at trial, and what you saw on the view. You may not guess or speculate about evidence. You may only consider what has been introduced into evidence and the reasonable inferences that can be drawn from that evidence. And by reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. As I explained earlier, during the trial, the lawyers made objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I ordered that a question and answer were to be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and allowed a witness to answer a question, you're not to give any such evidence any special importance because of my ruling. When I rule on an objection, I am merely applying the law as is my duty. If you believe that I suggested or expressed an opinion as to any facts in my rulings, you should ignore such opinion. The court in this case, as in all cases, is completely neutral and impartial. It is up to you alone to decide the facts of this case. Now, there are two different types of evidence. There's direct evidence and circumstantial evidence. Direct evidence is direct proof of a fact, such as testimony of a witness based upon personal knowledge. That is, what the witness saw, heard, or otherwise experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of some other facts. There's a simple example which I use to demonstrate the difference between direct and circumstantial evidence. Imagine that as you were sitting here, you looked outside the windows of this courtroom and you could see that it was raining. That would be direct evidence that it is, in fact, raining. Now assume that you were sitting in this courtroom and it didn't have windows, but that as you're sitting here, someone walks in the courtroom and they're wearing a raincoat and they're carrying an umbrella, and the umbrella and the raincoat are dripping wet. Now, you can't see outside, so you don't have any direct evidence that it's raining outside. But on those facts, as I've asked you to imagine them, it would be reasonable and logical for you to assume that it was in fact raining outside. That's all there is to circumstantial evidence. Based on reason and common sense, you infer from an established fact the existence or non-existence of some other fact. You should consider both types of evidence. There's no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You're permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it's direct or circumstantial. However, there is one rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offense, then to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if from the circumstantial evidence it's rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. Therefore, if there's a conflict between witnesses who offer direct evidence concerning certain facts, you should seek to resolve the conflict. For example, suppose that there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies the defendant did not commit the crime. That presents a situation where there's a conflict in direct evidence. And in that situation, you, the jury, should attempt to resolve the conflict and must decide whether, based upon all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. So in summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that's important. What is important is the quality of the evidence. In deciding whether the state has proven a charge against the defendant beyond a reasonable doubt, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there's any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest you consider a number of factors. The witness's appearance, attitude, and behavior on the stand, and the way the witness testified. Whether the witness appeared to be candid. whether the witness appeared worthy of belief, the witness's opportunity and ability to see or hear the things about which the witness testified, whether the witness has an interest in the outcome of the case, the accuracy of the witness's memory, any bias of the witness or friendship or animosity the witness may have for or against any of the people in the case, whether the witness had any reason for not telling the truth, whether what the witness said seemed reasonable or probable, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case or with prior statements by the witness. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you're not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though their testimony is uncontradicted. Nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a large number. You can accept all of what a witness has said to you. You can reject all of what a witness has said to you. Or you can accept some of it and reject some of it. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. Under our constitutions, all defendants in criminal cases are presumed to be innocent unless proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person unless and until the state convinces you beyond a reasonable doubt that he is guilty of every element of the alleged offense. If, after all of the evidence and the arguments, you have a reasonable doubt as to the defendant having committed any one or more of the elements of the offense, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based upon reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this: if you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the crime charged beyond a reasonable doubt, then you should find the defendant guilty. Now, the laws of New Hampshire set forth certain crimes, and each crime has a precise definition with at least two parts or elements. There's a mental state and there's an act. And in deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his mental state was. For a person to be guilty of a crime, he must have the requisite mental state and he must have physically acted to do something that is criminal. The word act refers to a physical deed. The word mental state refers to what a person mentally believes that his physical act will accomplish. For a person to be guilty of a crime, he must have physically acted to do something that is criminal, and he must have had a particular state of mind. Unless a person both acted to do something that is criminal and had the required mental state, the person has not committed a crime. To understand how mental state works, consider this example. Suppose two different automobile drivers hit a pedestrian who was crossing the street. Suppose that one of those drivers hit that pedestrian deliberately, whereas the other one did so out of carelessness. The two drivers would be guilty of different crimes, even though they both committed the same act, because they had a different mental state. One did it purposefully, and the other did it carelessly. Those are the different mental states. The matter of determining a person's mental state is something that you will have to decide. There's often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and all the circumstances based on the evidence presented in the case in deciding whether the state has proven that the defendant had the requisite mental state and acted to do something that is criminal. All right, so now I'm going to explain the two different charged offenses in this case. So count number 1, and this is charge ID 2228154C. You don't need to remember that. But in count number 1, the defendant is charged with 1 count of attempted murder. The indictment alleges that on or about the 4th day of April 2024, Jason Levesque, acting with the purpose that the crime of homicide be committed, repeatedly shot Kyle Violette with a 9mm pistol, which, under the circumstances as he believed them to be, constituted a substantial step toward the commission of the crime of second-degree murder. So, in order to prove that the crime of attempted murder has been committed, the state must prove each part of the following definition beyond a reasonable doubt. So 1, that the defendant intended that the crime of murder be committed. That is, that the defendant acted with the purpose that the crime of murder be committed. Purposefully is defined further below. The crime of second-degree murder requires that a person causes the death of another. This means that the death of another person would have been the direct result of the defendant's actions. That was number 1. Number 2, the state must prove that the defendant took a substantial step toward the commission of the crime. The acts must be more than mere preparation to commit a crime. The acts must be a substantial step towards the commission of a crime. A substantial step means acts which strongly support the conclusion that the defendant intended to commit the crime of murder. Here, the state claims that the defendant committed the following acts. He shot Kyle Violette repeatedly with a 9mm handgun. It is up to you to decide whether this act constitutes a substantial step toward the commission of the crime of second-degree murder. Those are the elements of the crime of attempted murder. Certain words in that definition need to be further defined. The first is purposefully. Part of the definition of the crime is that the defendant acted with the purpose that the crime of murder be committed. This means that the state must prove that the defendant had the conscious object to cause Kyle Violette's death. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means the defendant desired to cause a certain result or to do the prohibited acts. It's not enough for the state to prove the defendant knew or was aware of what he was doing, nor is it enough for the state to prove the defendant created a risk of injury or harm. To prove that the defendant acted purposefully requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do particular acts. Now, at this point I'm going to instruct you on self-defense, because evidence has been presented that the defendant acted in self-defense. When there is some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend himself or a third person if 3 conditions are met. 1, that he actually believed that the other person was about to use deadly force against him or the third person. In other words, the defendant could use deadly force if he actually believed that he or a third person was in imminent danger of death or serious bodily injury from the other person. Now, serious bodily injury, for purposes of understanding self-defense, means any harm to the body which causes severe, permanent, protracted loss of or impairment to the health or function of any part of the body. That is serious bodily injury. So a bump or a scratch or a bruise would not constitute serious bodily injury. As the words imply, serious bodily injury requires a serious or significant injury. So that was number one, that he actually believes that the other person was about to use deadly force against him. Number two is, even if the defendant actually believed that such danger existed, that is, that either he or some other person faced an imminent risk of death or serious bodily injury, that belief must have been reasonable. In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful deadly force against him or a third person. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the other person was about to use unlawful deadly force. Third, the defendant must reasonably believe that the amount of force he used was necessary for self-defense. A person is not permitted to use excessive force in self-defense, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there was reasonable grounds for his belief. So those are the three conditions that must be satisfied in order for self-defense to apply. I'll now move on to the second charge in this case, count number 2. In count number 2, the defendant is charged with one count of first-degree assault. The indictment alleges that on or about the 4th day of April 2024, Jason Levesque knowingly caused bodily injury to Kyle Violette by means of a deadly weapon, in that he shot Kyle Violette repeatedly with a 9mm handgun. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused bodily injury to another person, 2, the defendant did so knowingly, and 3, the defendant caused the injury by means of a deadly weapon. Those are the elements of the crime of first-degree assault. Several of the words in that definition require additional definition as well. First, bodily injury. Bodily injury means any harm to the body of another person. Knowingly. Part of the definition of the crime of first-degree assault is that the defendant acted knowingly. This means the state must prove that the defendant was aware that his acts would cause the prohibited result. The state does not have to prove the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware or knew that his conduct would cause the result. And third, deadly weapon. The term deadly weapon means any substance or thing which in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. And I will instruct you that a pistol or other firearm is a deadly weapon under New Hampshire law. I also remind you that for this second charge as well, some evidence has been presented that the defendant acted in self-defense. And as I explained before, when there is some evidence of self-defense, the state must prove beyond a reasonable doubt the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. And for further explanation of the law of self-defense, you can always refer back to the more full instructions I gave in count 1. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the indictments should not influence your verdict with respect to the other indictments. Members of the jury, this case is important to both the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should not decide this case out of bias or sympathy, but with honesty and understanding. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. That means your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so honestly and in good conscience. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purpose of returning a verdict. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to each of the charges before you. If you have a reasonable doubt as to whether the state has proven any one or more of the elements of the offenses charged, you must find the defendant not guilty. On the other hand, if you find that the state has proven all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. Now, because only 12 jurors will be deliberating, it is now time to select the alternates. And the alternates in this case are going to be jurors number 13 and 14 who are going to be assigned to be the alternates. As alternates, you will not be participating in the deliberations, but you still have an important role to play in that if one of the jurors were to be unable to continue, you would have to step in and deliberate in this case. So the alternates, you are going to have to remain in the courthouse until the case is decided, and you must continue to follow all of the rules which I have given for the conduct of jurors. One of the first tasks you will have once you go back into the jury room is to select a foreperson. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described and should make sure that each juror has full opportunity to present his or her opinions and arguments. If any questions concerning the law should arise during your deliberations, the foreperson should write out the questions and hand them to the court officer. The officer will bring the question to me, and I will respond in writing as soon as I am able. I further instruct you that transcripts of the trial testimony of the witnesses are not available. In a few minutes, we will have copies of my instructions. You'll be given those. You'll be given the exhibits. They'll be brought into the deliberation room with you as well. Remember, I told you the firearm will not come back with you as an exhibit. If for some reason you decided you wanted to see the firearm to inspect it, we would have you come back in the courtroom and arrange that. We will also provide you with a laptop and the necessary software so that you can view the videos. You should take as much time as you like. When you have arrived at a verdict, let the court officer know, and you'll be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. I also will point out, in addition to the instructions that I'm going to have sent in with you, you'll be given a jury verdict form. It's very bare bones. It just lists the two different charges and has a checkbox for guilty or not guilty. So the foreperson will fill out this form and then tell the court officer that you have a verdict. Okay? Before I let you go, counsel, anything further we need to address before I let the jury go?